Are you
rude to
threatening
the
someone
staff
in
at
my
the office here,
courtroom?
the female staff at the office here.
Not at all. Not at all. I know you don't want me to interrupt.
I tend to believe it because he's rude in court. He won't be quiet while other people are talking. Okay. Thank you. I'm satisfied with the reductions that was made, and I will grant the request for attorney's fees in the amount stated on the record. Can you produce an order?
Yes,
for
Sharon.
attorney's fees and costs, that is. And you can send it through my file. Do you have any questions, sir? You're shaking your head. Does that an indication of no?
Yeah, I have zero words as to what to say on how I paid $11,000 to a defendant when my case had, it's not without merit. It's got, if I was to refile it, if I had an attorney, if I didn't take 6 months off from getting run over by a car, I would have been able to afford to buy an attorney. It's not that I couldn't pay his brother the $1,300 that I owed him at the end of the job. I paid for everything in advance before he even ever showed up. I have always made decent money, and I've always done really well in life. I treat people with respect. I don't rob people blind. I change tires for next to nothing. I'm every day for the public. I go above and beyond for my people, my customers. I've done so much for them, even not even just in regards to this roof or using them through business, just in life, just have helped them in multiple ways. Anytime they ever called on me on my service, I've always been there for them. So to go through this, it's affected me. It's got me in a position where I don't even know what my next move will be. Like, that's where it makes me feel. I should not owe this man nothing. Well, the $1,397.86 that he's trying to say that I owe him, $386 was added on after the contract was already complete. According to both of us, he should have been completing the job.
This is not a time for us to rehash the trial. Again, I put it on the record, this case it's almost a year from the time that this case initiated. And so you were advised multiple times that you probably want to seek counsel because court rules, it's not about, you were the one who brought the lawsuit. And if you were going to bring a lawsuit, then you need to either reverse yourself with the court rules and the procedure so that you know how to move forward, or you were going to have to hire you an attorney. It's a civil matter. Most attorneys will take a civil matter on a contingency fee, meaning they see some merit and they think that they can get paid the same way he got paid after taking the case. They'll seek their attorney's fees and they'll get their money through that. Nonetheless, the court rules are the court rules, and you did not prevail. There was also an opportunity for you to resolve this matter because he proffered an amount to you to resolve and settle this case, to which you didn't accept. And that's really what set him up to be able to request attorney's fees, because there was a way to resolve it that didn't happen, and then you were then unsuccessful. If you were able to be successful with your claim, he would not be in this position to seek this amount of attorney's fees. So the court rules were clear as it relates to that. It's unfortunate. If you had evidence that you believe would properly have supported your case, you didn't present it at the time of your trial. And so that's what puts you in a very, very hard situation, is because that's what the trial date was for. You were supposed to bring your evidence. There was too much. I didn't have the evidence, or I left it here, or this person had it. Any other questions for the record? Because I'm not going to be, when you talk, I checked myself to be quiet because I wanted to let you have a moment to relieve what was out, whatever was on your chest. But what I won't do when I'm talking is be cut off. This was the same thing I saw even when you were having your deposition, and I saw the attorney being patient and explaining to you, we can't both talk. So I'll let you know when I'm not talking, you're going to talk, and you wanted him to let you know when you can talk. No one's going to have to let you know when we're talking, because if we're talking, you should know you shouldn't talk over us. But when a question is posed to you, then you should be able to know when to answer it. When you were talking, I listened. Now I'm talking. You want to cut me off. I heard your case. I spent way more time than this case should have required to resolve it. I gave you more time than necessary to try to bring your stuff in here. I gave you all kinds of allowances. That costs time. That costs time for the attorney. It costs time for the court. But you still didn't bring us what we needed on the date set for trial. You didn't even have this witness that you named. So the ruling was what it was because you weren't able to sustain your burden. It's your burden to produce the evidence for the court to establish your cause, and you were unable to do that. And judgment was in favor of the defense in this matter, and as a result, there's now attorney's fees in the amount of $11,316.
Can I ask one thing?
Yes, you may.
How could it go from him thinking he's gonna settle with me, owing me money, which I misunderstood?
I can't opine. I can't opine over. So the way negotiations work, it's not really up for the court to opine as to what, it could have just been value of his time. We'll give you $600 to make this go away. It could be just a value of his time. We're gonna give you this money to make you go away so that we don't have to deal with this. There's a number of things that go into why defendants and or plaintiffs offer settlements. I was not there. I couldn't do it. I don't even know if you counter offered. It's not really germane. All I know is that there was an offer to settle and you refused to settle. I don't see anything where you even countered. And so
I'm not trying to cut you off, but I misunderstood. When I went to his office for the deposition, I was very upset. I did not want to be there. I was supposed to be at a doctor's appointment for my car accident. And he said if I didn't come, that I was going to be charged all this stuff. He was like, I got the emails. He basically threatened me that if I didn't come, that it was going to be a big problem.
Sir, you've been upset every time you've come.
Yeah, because this is
you filed the litigation. When you file litigation, it comes with stress, it comes with paperwork, it comes with understanding these rules. And so you brought it, and every time you came to court, even when you came for the pre-trial, I had to intervene. I shouldn't have had to intervene just for you to complete a joint pre-trial statement, but I had to because of your attitude. I'm not dealing with it anymore. This case is done. You're all set.
We're off the record, Your Honor, on this matter?
We're off the record. Thank you.
Thank you. Okay.
So are you threatening someone in my courtroom? Are you threatening someone?
No, I'm saying we're
Run?
done. I said,
Run for what?
I said we're done.
Exit out the courtroom, sir, before you find yourself in contempt. On the record in the matter of Anthony Pryor versus Simon Zaney. And this is 23-02133 GC. Counsel, can I have your appearance?
Good morning, Your Honor. Attorney Cooper Dobies on behalf of defendant / counter plaintiff Simon Zaney, who is standing to my right and appearing by Zoom as well. And I am standing in for attorney of record Edward Zaney, both with Edward's permission and the permission of my client this afternoon.
Okay, today, Mr. Pryor, state your name for the record.
Anthony James Pryor.
Okay, present via Zoom. Today was the date that was scheduled for an objection to installment payment order. The defendant counter plaintiff has filed a motion for installment payment order asking to pay $150 per month. It says see attachment of first two payments. I'm not sure if the clerk's office sent that up, but they did put a note. Mr. Pryor, did you seek to give payment to the court? Is that what happened?
No, what happened is after I found out that the judgment was made, that it was entered against me, that you told me in person that I was gonna have to pay Edward that money. And so I tried communicating with Edward a few times by email with no response. And then I remember you telling me that I needed to probably just go to their office and make an arrangement with them to figure out how to get them taken care of. And so that's what I did. I just went in there and I took two payments because I had those two payments over the course of emailing them for a couple of weeks with no response. I still got the payments around and made sure that I got those to them. And so I just went and took them and dropped them off to him. And then I made a photocopy of them and put them in with my stuff that I gave to the court a couple of weeks ago.
Okay, sounds good. And then the plaintiff, you are filing an objection to the installment payment order.
That is correct, Your Honor. Yes, that's correct.
What's the basis of your objection?
A couple of bases, Your Honor. Just to briefly highlight a couple of points in the motion or in the objection that we filed, the written response we filed with the court. The first issue is that the form that Mr. Pryor filed, this form MC-15, on its face, it was never properly notarized, which is required by the statute. And it even mentions it on the form. There's an area above where it says certificate of mailing. The copy that we have of it, it says subscribed and sworn to me on, and there is a date. There's no other notarization of it related to that. So I would just direct that to the court's attention first. We have no indication that Mr. Pryor himself is a notary, even if he was a public notary.
Excuse me, don't interrupt, please. We've gone through this, Mr. Pryor. Keep going, counsel.
Thank you, Your Honor. Even if Mr. Pryor was a notary, there's no indication on the copy that we have that it ever was notarized by anyone, whether it be the court or otherwise. There's no appearance of that. The second point I would like to make is that this matter is governed both by the Michigan court rules and statute. Specifically with regards to the Michigan court rules, we're looking at MCR 3.104. That court rule should be read in tandem with MCL 600.6201. And MCL 6.201 specifically states that a party in Mr. Pryor's position does not have standing to ask for a payment plan in this matter. Mr. Pryor was sanctioned under MCR 2.405D, and in that capacity, he was sanctioned as a plaintiff. So Mr. Pryor is a plaintiff. We understand that he is also a counter defendant, but he is a plaintiff that is attempting to reframe himself as a defendant for the purposes of attempting to enter a payment plan before this court for a judgment that was entered against him, again, in the capacity of being a plaintiff, not a defendant. The plain language of, as I mentioned, MCL 6.201 specifically states, and I'm quoting here, I'm taking a part of the statute here, upon proper showing made by defendant, unquote, an installment plan may be entered. Again, I would reiterate that in the capacity that Mr. Pryor had a judgment entered against him, he was acting as a plaintiff, not as a defendant, while still acknowledging that, yes, he was a counter defendant in this matter as well. Not in the capacity, he was not acting as a counter defendant when he had a judgment entered against him. He was a plaintiff. The third point I'd just like to highlight again, Your Honor, and we did make this point in our pleadings, going to MCL 600.6205, that has a mandate, quote, the affidavit of the moving party setting forth his inability to pay the judgment with funds other than those earned by him as wages, unquote. Quite frankly, Your Honor, all that we have is a handwritten computation with, I would position, no substantiation as to how he got to those numbers. And quite frankly, Your Honor, there was a deposition of Mr. Pryor in this matter that Mr. Zaney undertook. And the sworn testimony at that deposition actually contradicts.
Mr. Pryor, Mr. Pryor, are you carrying on a conversation with someone else right now?
I was trying to tell my husband when he's standing in the window that I have to go get my daughter.
Okay, well, if the other thing is you
I'm
can't
listening
operate
to him.
You can't operate a motor vehicle while you're in court.
I'm sitting in my driveway letting it warm up.
You can continue, counsel.
Thank you, Your Honor. The sworn testimony of Mr. Pryor at his deposition actually contradicts the computations that he provides the court, if the court is to believe those computations in the first instance. Mr. Pryor testified to having multiple stocks when he was asked what residual investments he has. He cited that he uses cryptocurrency to buy and sell stocks and that he has a crypto.com account. He was asked how he paid for the roof, which started this whole matter, and the court's familiar with that. His answer, and I quote, was, "I sold crack," unquote. And he also mentioned that he owns a house in Florida on land contract at 618 Southwest Racher, Racher Road. And in all candor to the court, I was not able to verify that that address exists, but Mr. Pryor has made statements that he does own property in Florida. So this is all four of those sources of income are outside what he is earning by wages, and it's the position of plaintiff here, or I'm sorry, of defendant counter plaintiff here, that is all income that's outside of his wages, that it contradicts the attachment to the motion for an installment plan in this matter. And just finally, Your Honor, I would be remiss if I didn't mention this. I believe Mr. Pryor alluded to this a little bit in his initial statement, although I think it's a gross mischaracterization of what occurred. Mr. Pryor attempted to serve what I have two MoneyGram orders that I have here. He attempted to pay these or serve these on to Mr. Zaney, Mr. Edward Zaney, that is, at his office. It was at his office. I would just like to note for the record that this took place before Mr. Pryor filed this motion for an installment plan. It was almost Mr. Pryor attempting to start his own installment plan without any sort of order from the court. And I would just like to note both of these MoneyGram payments are $150, which I believe is the exact amount that Mr. Pryor is attempting to start this installment plan with. So I think that that's a bit too coincidental, as I mentioned. And again, Mr. Pryor was quite rude to the staff at the office here, the female staff at the office here.
Not at all. Not at all. I know you don't want me to interrupt.
I tend to believe it because he's rude in court. He won't be quiet while other people are talking.
I'm not rude in any way to anybody ever.
Talk again over the other party, and your motion is dismissed, and you'll be sanctioned for disrupting the court.
Yes, ma'am.
You can continue, counsel.
I would just like to wrap up briefly with a little bit of recap of what my final point there. That again, he was quite rude to not court staff, to our staff here in the office, who was not familiar with Mr. Pryor, was not familiar with his situation, was not familiar with his relationship to this case. They merely were doing their jobs, and Mr. Pryor approached unannounced, might I add, in this matter, and attempted to again serve these pay these two $150 payments in this matter. So again, Your Honor, we would just be asking that Mr. Pryor not be allowed to have this motion for installments for the multitude of reasons that I stated on the record and more thoroughly developed in our written response. Thank you, Your Honor.
Thank you. Mr. Pryor, now would be your opportunity to respond to their written objection to your motion for installment payment orders.
Yes, ma'am. First of all, I want to apologize to the court because, for one, I believe that I'm always misunderstood.
Your connection is bad.
I went to their office. Nicole.
Sir, we lost you for at least 30 seconds there. Your connection is bad.
Okay, sorry. It's probably my battery's getting connected for a long time. Hello, are you there?
Yes.
Okay, so I'm usually misunderstood. People take me for what I say and do as attitude, and it's really not. It's usually just I'm a direct and I'm straightforward and I'm very passionate about what I do. I went to their office to make payments because that's what I know needs to happen. It was a direct intentional payment of $150 on both of those payments because that's what I was communicating with them that I could afford to make each time I made a payment. And during the interim of not being responded to, I made two payments, but I never delivered them because I thought maybe we'd get a response back from them, but I did not. When I went to the office, at their office, and Nicole was standing is actually sitting at the desk, I specifically said that I was emailing Edward for the last couple of weeks with no response. I was in no way rude. She might not know me, as he stated, physically in person, but I believe she was there when I went to the deposition. And so she knows about my case, and she does very familiarize. She sent me emails about my case before because I've sent her emails about my case.
Okay.
And they
don't
told
want
me
to talk about that right now.
Okay,
That's
well,
really
I'm trying to cover all the points that he just made.
I'm trying to stop you, and you're going to let me stop you because I don't want to hear about it. I want to hear why you believe that you, per the Michigan compile law, you have the right to request an installment payment order as a plaintiff. That's what
Okay,
I want to hear about. That's
yeah.
A. I'm not finished. I'm not finished. I also want to hear more about your representation of your finances, because we
Yes,
do
ma'am.
have a sworn statement under oath from you that indicates that you have multiple stock investments, cryptocurrency, some engagement in some unauthorized sellings, and property in another state on a land contract. And then I have a handwritten statement that you wrote about your finances, particularly one of the highest one on here would be a house payment. I could be wrong. Did we still open an eviction for this? Or was that closed?
I think they might have closed it because house fire.
Because what?
House fire his land contract and they did like not pay it.
Yeah, my understanding is you don't pay that based on some court filing. So you need to give me some, those are the things I want to talk about. I don't really care about being rude in the office.
Okay. All right. So under oath, you're considering the deposition that I did at his office under oath. I was under very much stress. And I did say some smart remarks that weren't accurate. I made smart remarks to Simon and to Edward when they were there in the office, interrogating me and putting me on the spot about my previous history, about other things that had nothing to do with my roof. And so, yeah, I made some smart comments to him about doing some things that I shouldn't do there, that nobody should ever do. But that's because they know damn well what I do. They know exactly clear what I do for a living when I was working. This whole year, from February until the end of August, I didn't work because I was out on medical. And so I went back to work in the beginning of September. My finances that I wrote down in that list are exactly accurate to what I have going out the door. And what I have bringing in right now is less because I just got back to work. And so it's very accurate. I don't have the cryptocurrency that I have like $380, and it's on, I said crypto.com. That was a lie. It's on Robinhood. I've got like $382 on Robinhood. Originally back in like 2019, I had like $15,000 invested on Robinhood, but I lost a lot of it when all that stuff went through the roof, and I made some more investments to diversify myself, and then it all went back down. And so I lost my tail. I can prove that. I can log in, give you the information. I don't care about that. I'm paying every month for my house payment $1,000 a month. It's not going to the person that I'm making the deal with the house on, because we're having a disagreement about whether it's a rental or it's a purchase. So in her consideration, it's a rental. And so in my documentation, it's a purchase. And in the fact that I win a case against her in the future, then that would be accurate. I may have some equity in my home eventually later down the road, and I don't have now. But that's not something that I have floating around. I don't have any property in Florida. He miswrote the street name, and when he said it back to me, I let him say it back to me wrong. If you go back and listen to the deposition, I said Archer Court, and he said Rachel Road, and I just said yes. Yep, that's what it is. And because I was upset, I was angry. A lot of people misinterpret what I do and say as being rude or obnoxious or out of control, and that's not really who I am. I'm a good person. I help people. I spend every day of my life helping people, all day.
Sir, we don't want to hear about that anymore. You've told us
I know you don't.
Come to court. I know about you helping people, and you always want to construe it as you being misunderstood. But if you continuously talk over people, if you're aggressive, if you're threatening, if you're swearing, then you're not being misunderstood. You're being rude.
Okay, well, in their presence, in their office, under that situation, it was high stress, and that's just what happened.
Okay, what about the court rule? The court rule does not provide for a plaintiff to file for an installment payment order. You are not a plaintiff. I mean, you are not a defendant. You are a plaintiff in this matter. Did you have a response to their objection based on that?
The only response that I have to you is, I mean, I am the plaintiff in the original case. In the counterclaim against me, for attorney's fees, I believe I am the defendant and I should have rights to pay in a normal manner. I mean, I've already made an effort to do so, and I'll even make an even extreme. I'll give everything I possibly can, every chance I get to get it paid, because I don't want to have to file bankruptcy to just wipe it out completely. I could. I don't have anything else that would stop me. I mean, I could just do that. It'd save me all kinds of time and aggravation and headaches. I could just put it to rest with that. I don't have anything else, any other debts that would be affected by it. And I've already consulted an attorney. And I mean, I was trying to not do that, but.
Anything else you want to provide to the court for consideration today, sir?
No, ma'am. I do my best in everything I do. That's it. And that's all I can do. I don't have the money just laying around. I don't have any properties in Florida. I don't have any interest in anything that's just laying around that they can just come take from me and just go do what they wish with. I'm not that. At one point years ago, when they knew me from a long time, that's the case. Yeah, I could have just went and given them money and just paid them. But no, that's not who I am today. I've been through a lot in the last decade. If you go through my personal history, you can look at my history. I think I filed bankruptcy once before. I've lost an entire business due to family taking it from me. At one point, it was worth millions of dollars. And so, yeah, at one point, I did have a lot of ways that I could have paid them immediately, but that's not today. Today, life is different for me.
Thank you. Thank you for your response. Counsel Dobies, I don't know if you had any further response, but I did want to respond on Mr. Pryor's behalf as it relates to the filing of his affidavit. It does not need to be notarized. It was signed by the clerk in the clerk's presence, and so that it was properly filed. My question or concern for you, Mr. Dobies, is how do you intend for Mr. Pryor to pay this? You think he's going to pay a lump sum to Mr. Zaney's office?
Your Honor, I think that there may need to be a debtor's exam in this matter, and I think that that's exactly how we're going to ascertain exactly what the situation is, because quite frankly, we don't know either. And part of my response to that is that, Your Honor, I believe Mr. Pryor admitted he committed perjury in his deposition. So we almost can't rely on what Mr. Pryor said in his deposition at this point, but based on his sworn statements at his deposition, we believe he does have assets that that may be collectible in this matter. We just don't know yet.
Okay, so it's your position that your office wants to proceed with a debtor's exam and get some discovery?
Yes, Your Honor.
You've not served him with such notice yet?
We have not yet. No, that may be a couple steps ahead of where we're at, but I believe that that's where this is going to have to go. Yes, Your Honor, that's correct. But we have not procedurally filed the appropriate paperwork for that to occur yet.
Well, I need to know, because I think that may have some bearing on how I'm going to proceed. If you're going to do a debtor's exam and do some discovery into his financial ability to make a payment, I think it's reasonable, even if he hadn't made statements that we now can deem as perjury. Just by nature of the fact that he owes a debt, you had the right to discover information about his financial resources. And so if in fact he's in a position where he can't do more than what he's offering, then I think he's being forthcoming, he's making that, and I would be amenable to granting him an opportunity to make installment payments, even though he's not deemed a defendant in this matter. But if it terms that maybe we don't know how to believe what he's saying because we don't know when he's being facetious or when he's being forthcoming, then maybe he does need to make a lump sum payment. I don't know. It may require an evidentiary hearing. I'm not sure. But I'm going to leave that to you in your office as to whether or not you want to proceed with a debtor's exam and subpoena certain documents to be produced so that you can know best how to proceed on your end. And then that'll let me know, because I don't want to sign this installment payment order and then your hands are tied as to garnishing and getting other things when we could have did some discovery first. Mr. Pryor, you're raising your hand. Yes.
Yes, I'll provide those documents to you willingly to save everybody the time. I'll give you my bank record. I'll give you the Robinhood records. I'll give you all that stuff. I'm not lying to you in front. I did that because I didn't feel like I was under oath, and that wasn't like any kind of real. That was me being at their office being harassed to me at that time.
No,
Like,
you were under oath under the penalty of perjury, sir. So if you lied, then that's unfortunate because that's perjury, and there's a penalty for that.
I'm sorry, and I didn't mean that, but there was no judge in that room, so that's why I said what I said.
Doesn't have to be a judge in the room. It's just like if you sign something, you signed this paperwork when you came to the court, and they're saying that it wasn't notarized, but you signed it in the presence of the court of the clerk. A judge didn't have to be there. You were supposed to tell the truth on that document. That's what you were certifying. Nonetheless, I recognize that you're willing to turn over certain documents. There may be other documents they may be willing to subpoena. I'm going to reset this to allow them an opportunity to subpoena the documents that they want you to turn over. You can turn those over. They can review it, and then we can have a follow-up hearing review for this. And I'll make either a ruling, or maybe they'll be satisfied at the time of their next hearing date to see that this is probably the only way they're going to get their money. They may see your finances and realize there's nothing else that they can get. Do you understand, sir?
Yes, I'm not lying to you in any way. So yes, ma'am, I understand.
All right, give me a new date.
January 17th at 2.
Does January 17th at 2 work?
Your Honor, just one moment. Let me pull up our calendar here. January 17th at 2 p.m. you said, Your Honor?
Correct.
That does work.
Okay, we'll set this out for then. In between the Mr. Pryor, you should expect to receive a subpoena from their office for certain documents that you could turn over to them. And you said you're willing to do that. You should do that immediately. That'll give them time to review it before our next date of January 17th so that we know how to best proceed on your motion, okay?
No problem. Thank you.
Okay, any additional matters for today's record?
No, thank you, Your Honor. None from our side.
Anything else from you for today, Mr. Pryor?
No, I appreciate you, ma'am, and I hope that you understand like what I meant by being under distress and saying what I said in their office. And it was very uncomfortable for me to be there. So I thank you.
You're all set for. Thank you. You're all set for today.
Yeah, bye.
Thank you.
And then these parties, Mr. Dean.